Good morning. We have an immigration update with regards to the recent memo that was passed yesterday on May 21st, and we just saw it early in the morning. And we want update. This is about the adjustment of status. It is saying that it is up to the discretion of the USCIS, and they may not approve the adjustment of status unless there is extraordinary circumstances showing that the person needs the adjustment of status in the United States. So this affects the people who have already applied the adjustment of status, also called as 485 application. It also affects the people who intends to file the 485 application. In a sense, what they're telling is that, let's say, for example, somebody comes an F1 visa, changes to H1, and now they changes to adjustment of status. They're going to look into why you did not depart after the F1 visa. Even if people have come on H1B visa, it's a dual intent visa. People can have an intention to settle in the United States. They say that's not enough for them to have a favorable discretion to give them the green card. Emily, can you tell me what is happening on this thing?
Yeah, so with this memo, USCIS is saying that the general rule should be that every single person applying for a green card should consular process, meaning you are outside the US, you apply for an immigrant visa at the consulate, and you enter the US after that process is complete. The alternative is adjustment of status, and they're saying that in order for someone to qualify for adjustment of status, that is a matter of discretion, administrative grace. It's an extraordinary form of relief. Therefore, we're not going to allow it in most cases. They are considering that filing for adjustment of status is a negative discretionary factor when you should have departed the US. And you have to then provide all of the positive discretionary factors that will outweigh this one negative discretionary factor in order for them to agree to let you adjust status and approve your I-485 application. So we've been talking a number of times about USCIS using discretion, how the Trump administration and Stephen Miller is changing that when it comes to filing for extension of status, change of status, and they're using these law enforcement interaction as a reason to deny an extension of stay, to deny an EAD, to deny a change of status. We've seen it expanded to 485s recently. I think I've come across 3 or 4 denials just in the last week where USCIS sole reason for denial. They say you clearly qualify for adjustment of status. You've met all the requirements, but in our discretion, we're denying it because of A, B, and C negative factors that they think apply to this particular person. This takes it to a whole nother level. This is on steroids to where they're saying adjustment of status itself is completely discretionary, extraordinary form of relief, and we're not going to let anybody do it unless you can prove that you have all of these positive factors to outweigh the fact that you did not depart when you should have. Even though you're in a dual intent visa, even though you're on H or L, your failure to depart is highly relevant to the analysis and therefore is considered a negative factor.
So is it applicable to everybody, Emily, or is it only applicable to the new cases that are getting filed?
It does not provide an effective start date. The memo is written in such a way that it's just a reminder to officers of how adjustment of status has long-standing been, decided. And so therefore it applies to everything. Cases already filed, everything pending right now. They could choose to deny every single 485 pending right now as a matter of discretion, or at least send a notice of intent to deny and give you a chance to provide your positive discretionary factors. So this is not just a forward looking, it applies to everything already filed and anything to be filed in the future for all 485 applications, regardless of the type, regardless of your status, regardless of the category, regardless of your country. All 485s will be subject to this today.
We're getting live questions. So I just want to reiterate that this recent memo is applicable to the existing adjustment of status and future filing cases. When the filing dates are current or final action dates are current, this memo is applicable. So, Stephen, do you think so? They will start denying the 485s unless they see a totality of the circumstances that will favor in their discretion? Or is it that they're going to it's just an excuse for some of the denials that they are doing, or will they do they intend to do more denials? I want to Stephen Brown, I want to keep you in intention what Stephen Miller wants to do.
Yeah, I think he spells his name differently. He's one of the evil Stevens with the PH. You know, I think with even with this memo, Rahul, I think they can't just turn around and say we're denying everything today. I think there would have to be an opportunity to respond procedurally. That they say, hey, we don't think we're going to exercise discretion, so prove it. I think they could. I do want to emphasize. I mean, we've all had this memo for maybe 3 hours now. We don't really know how they're going to actually apply it. We just have the text, which some of it is kind of, I don't know. They liked, I mean, I don't know. Maybe discretion was Edlo's word of the day calendar because it shows up quite a bit. But I think there's a lot of issues with this memo, but I think we're going to have to be proactive with it.
What do you mean by proactive? What are you going to do about it right now for the pending applications?
Number one, I think maybe I would try to, start putting together my evidence. Why should I? I think there's a lot of support. So let's just kind of go back to where this comes from. The INA does say that the secretary or the attorney general, it's now DHS, may in his discretion go through, with adjustment of status, right? So it all is, adjustment of status is discretionary, but it is still a procedure that the government created, and I think their regulations don't support this memo. I think it creates a higher evidentiary standard than what the regulation says, and I don't think this is actually discretion that is afforded to Congress to say you can't actually go through this procedure that we created. I can tell you there's a lot of people already. I've been talking all morning with people on potentially developing litigation. I will say, we don't have anything created today. We all had this for 3 hours. There's a lot of research that needs to be done, but it's already being discussed because I think there's a lot of open doors for litigation on this, that it's not discretion that's intended. It's abuse of discretion. I would say it's not even discretionary. Because it's not something afforded to them. It's a lot of issues with it. But, I also think, Rahul and Emily, we were talking about this. Go back in history. The 1954 INA allows for adjustment of status because they want to alleviate some of the burdens on the consulates abroad. Now let's fast forward to 2000 with the AC 21, right? This idea is we want to stop disruptions with high-skilled immigrants. We want to make things a little bit more flexible, a little bit smoother. So how are you going to say, we have this process of adjustment of status. We want to make things, Congress wants to make things easier, smoother, but now we're going to view it as a negative, that you're trying to adjust. I don't think it's going to fly. So we'll see how they actually apply it. But I can tell you a lot, this is being talked about already.
Emily, what do you think of immediate relatives, that is the spouse of U.S. citizen, parents of U.S. citizen, children under 21 of U.S. citizen? Let's say the spouse of U.S. citizen came on a B2 visa and now they are married after they entered into the United States. Or if the person is an F1 visa or if the person is an H1B visa and now they got married, how do they view this discretionary method and we should do the consular processing instead of actually filing the adjustment of status?
Yeah, I think that's what they're wanting people to do as a way to get you out of the country. And then, you're stuck with dealing with the consulate for who knows how long and what their process is going to be like. But yeah, I do think it applies to any 485. So even those that are married to a US citizen, immediate relatives. Um, I think that it might depend on the method of entry into the US. Someone who entered on a B visa or an F visa and then gets married and files adjustment may have a harder time compared to someone who entered on an H and then married a US citizen and files for adjustment. Because again, that initial visa is intended for you to come in for a short specified purpose and then leave. And they're saying your failure to depart in that time is the negative discretionary factor. And so you're going to have a lot of positives in order to outweigh that. Now, of course, we don't know how USCIS is going to weigh all the different factors and how heavily they're going to claim that the one negative factor that you didn't leave is going to outweigh. You could have 100 positive factors, and maybe they're going to say this one negative factor is so negative that there's no way to overcome it. I think that's what they're planning to do for F1, B visas, TPS, people that were paroled in, that sort of thing. For someone on H or L, they do specifically say that applying for adjustment of status for these dual intent categories is not inconsistent with maintaining your non-immigrant status. But in a little footnote, they also say that being an H or L by itself doesn't overcome this negative factor. So for H and L who marry a US citizen, I think you're going to have to be prepared to provide all those positive factors, which are your immigration history, family ties in the US, medical conditions, criminal history, connections to the community, anything about public safety, national security concerns. I'm hopeful that those will more outweigh the one negative factor for H and L. But for everybody else, I feel that their plan is to deny adjustment of status to everyone, regardless of how many positive factors you have, and force everyone to consular process.
I'm curious, Emily, if that's actually their plan or if it's, Friday and we want to dominate the news cycle, because we've seen that quite a bit. I mean, I think there's a lot of illegalities with this memo. I think there's a lot of issues with the vagueness, the legislature, all that. So we know that this administration loves to make announcements so they can dominate the news cycle. So they can say, we're doing this. And then we'll start, Tuesday, because Monday's a holiday. We'll get tweets from, press secretaries like, but whoa, all of y'all don't know how to read. That's not what we have. It's why I want folks. I mean, when I first saw this, my heart dropped a little bit because I was like, this is pretty messed up. I also, started going into thinking, but I also think we kind of have to see a little bit with what plays out on this too. I'm not sitting there saying we need to be complacent, but this is new, and I think flies in the face of decades of what they've done. And so I don't even know how they actually intend to apply this, to be honest.
Yeah, to your point, if you think back to the prior Trump administration, remember their big thing was public charge. And so they wanted to be able to use public charge as a way to deny everything, basically. So they created this 944 form, this declaration of self-sufficiency. Anybody filing a 485 had to include the 944 form. They had to include their credit score, their credit report, proof of their health insurance, and then all of these, positive financial factors. Did we ever see one 485 denied due to public charge for employment-based specifically? Never.
On RFE.
So this may be along those lines where they're making a big hoopla, as you suggest, and that for the typical run-of-the-mill employment-based, maybe, we'll have to add in some positive discretionary factors, types of things in the filing, but that they'll still approve them. But it just adds more risk and more uncertainty when Congress wanted things to be more flexible and smoother, specifically for employment-based.
And to your point on that risk, I mean, and I hate saying this because it goes against what we said the previous administration. I mean, up till now, I would tell people, yes, 485s are discretionary, but if you don't have an arrest and you don't have visa issues and you have a legitimate sponsor, your case is probably what, 95% chance that it's going to get approved, because that's how it goes, right? And so who cares about your non-immigrant status once you have the EAD and the advanced parole? Like, you're not going to ever need it again because this is going to be smooth. Should that, I mean, I would almost consider changing that advice. And I know we've talked about that all year, or last year and this year, because of a number of other things with automatic extensions of the EAD as well. But, right now, if you abandon your non-immigrant status and you get a 485 denied, you have to leave. There isn't an option. And then, are you subject to a proclamation or whatever? Unfortunately, for a government that's fixated on efficiency, this adds more layers to them, because somebody who probably could get off their H1 or their L or whatever might need to maintain their non-immigrant status.
Emily, you rightly pointed out with regards to the financial thing, that where we have been put like 5 to 6 pages filling out all that information out. We never got a single denial on that issue, especially for the employment-based immigration. And we never, and Stephen pointed out, not even a single RFE on it either. Not a single RFE on it either. Yet we had to go through all the burden. It could be that, or we have, like, for example, 60 days of grace period after the H-1B is let go. That is also discretionary relief, but we haven't seen any denials of people moving from company A to company B within 60 days. Of course, we have seen some reversals with regards to the B2 switching back to H-1B, but not from company A to company B. We haven't seen anything. It could be that way, or it could be drastic as, getting all the 485 denies unless we show the extraordinary circumstances why they need it. And they could point out in the DS-160 form, and when you filled out, you said you came on F1 visa, then you changed to H1. You never left after F1, you never left after H1B, or they could deny. We don't know at this point of time. So, and Stephen pointed out that it's only 3-4 hours. We're banging our heads. What are they going to do about it? Now, what do we advise for people right now? And the questions that are coming here right now is, I'm filing my adjustment of status. I'm married to a U.S. citizen. What are the steps that I need to take? I'm about to travel. It's a summer vacation for me. I have an advance parole. I have to travel. I am an adjustment of status, and I have an EAD, but I don't have a non-immigrant visa. Okay, should I get back to H-1B? What are your answers, guys?
Those are a lot of tough questions to answer right now. I think, if I'm someone who's married a U.S. citizen and was planning to file the adjustment of status, as of this moment, I would probably still file it. I would maintain my non-immigrant status after filing. If you're in a situation where, for marriage to a U.S. citizen, you don't have to be in a non-immigrant status. You don't have to have any status to qualify to file. Might want to wait and see what happens there. I don't know how safe it's going to be to file a 485 in that situation. For someone, who's employment-based and traveling on advanced parole, is it safe to travel right now? Maybe not, because it's possible that your 485 could get denied when you're outside the U.S. and you don't have an advanced parole to come back on anymore. So you would want to have that non-immigrant status. So I think right now, the most conservative thing would be to maintain your non-immigrant status, don't travel, and then maybe cautiously proceed with the 485, maybe include some of the positive discretionary factors at the time of filing, and, hope for the best at this point. But yeah, I think it's risky to travel on AP now.
I don't know. One question. To your point, I definitely wouldn't not file for adjustment right now. I mean, I think definitely I would proceed full steam ahead with that, because, with the understanding that maybe there's a greater chance of denial. But no, and someone just asked, and let's be very clear on the terms of art we're using here. This is not a change of status. So this doesn't impact, going from your F1 to your H1, although, Emily, let's not talk about it. This memo is fully about adjustment of status to a lawful permanent residency for the green card. So we just had 2 people ask that on YouTube about their H-1B cap cases. That's not what we're talking about. That's a change of status, adjustment of status for a green card. Very term of art.
So what you're telling me, this is not applicable from people moving from H4 or F1 to H1B. It does not affect at all. That's what Steven said. One question, a lot of people saying, okay, so what? We're going to do consular processing. This question is coming from ASTICA 7103 from YouTube and other people. That, okay, we're going to do the consular processing. It's not that easy, guys, consular processing, because consular processing involves a lot of delay, a lot of discretion. You're outside the country, and you may not, if they do put it, if some query on your thing, you may have to wait for a long period of time. There's a lot of discretion that they can use in denying it, the consular processing. So normal immigration lawyers are reluctant in sending the clients out there. Riga
Yeah, and I would also add, the consulates don't have the capacity to handle everyone who would normally file for adjustment of status now doing consular processing for their immigrant visa. They don't even have the capacity to handle the current number of non-immigrant visa applicants because everyone requires an interview now. How are they possibly going to handle the number of people that would normally file a 485 at the consulate? It's just going to create a huge backlog where people are going to be, waiting in the US for their interview to be scheduled for years because the consulates do not have the capacity to handle that many more immigrant visa applicants.
It's funny because I'm looking here at X, an attorney friend of mine who tweeted out a textbook. It's an older textbook, but it talks about it. 1952, the idea, Congress enacted the INA to include this adjustment of status, because, why was it better for someone to leave when it could be done here in the United States? And Emily, you and I talked about this morning. I think DHS with, HSI with, all the petition, everything, they have more information with DHS, with USCIS of the immigrant's journey than the consulate has.
Yeah, I mean, for people who are in the US, H-1B holders, L-1 holders, but other visa applicants as well, most of them have had to file petitions with USCIS, file applications for USCIS, provide their information to USCIS over and over again so that they could be vetted. And so USCIS could determine whether these people qualify for the visa that they're getting. And now, so all of that data is within USCIS. And so we know when someone files a 485 that USCIS goes through that data. They use that information to determine whether you qualify or not. Department of State might not have access to all of that same data. So they're the ones that would be adjudicating a immigrant visa at the consulate. I feel like USCIS is in a much better position to actually vet green card applicants compared to the consulate, who would be doing all of this from abroad. So I'm not sure how this makes us safer or more secure or eliminates fraud when the people that have the information aren't going to be the ones adjudicating the application.
And USCIS also has a better understanding of what's going on with all that. Department of State might see data points, might see numbers, might see parts of the petition, but I mean, USCIS has the institutional knowledge more so than Department of State. Let's take in, if there's past issues in an H-1B that is not an inadmissibility, but that Department of State would be looking at, that would be USCIS. So we'll see. How this goes in the next couple of little bit here.
So a couple of notes I made, Emily, that what we were been advising clients before and what we are telling right now is quite different, of course. So one thing is that what you said is maintain the non-immigrant status, which was not encouraged before by us, particularly me, Rahul Reddy. I would say that right now, until we know what's going on very clearly, if you are having a non-immigrant intent like H-1B or whatever status that you have, continue on that status instead of moving on to the EAD. That's one change for us, USC. The other change is that we told people that, oh, it's completely safe for you to travel on advance parole. Now we are taking that back. We are telling people that don't travel on advance parole until we will see how the things will, and we'll update the things. And also those people who are already outside the country on advance parole, I am advising them to come back into the United States as soon as possible, so that if there is any untoward action happens, it's better that we handle the things here in the United States. Now, people who have been on EAD, would I move them back to the non-immigrant status? Most probably no, because that may involve $100,000 fees because we have to do the consular processing. And also the consular processing, the things are not good. We are not getting the appointment. We are getting the 221G. So I would not take that step of converting them back into non-immigrant visas. But those people who are already here on non-immigrant visas, I will tell them to continue on the non-immigrant visas. Am I correct, Stephen and Emily?
Yeah, I would 100% agree with all of that. Until we see how this is actually being implemented, we need to operate under the assumption that adjustment of status is not safe as a status because it could be denied at any time. And so don't rely on your adjustment of status. Continue your non-immigrant status even after you file. Don't use the EAD. Don't travel right now. Don't use the AP. As you said, for people who've already switched and are relying on the adjustment of status and using the EAD, I think now is not the time to travel in order to get the non-immigrant status back, because that's more of a problem that's being created. But something to consider as we see how this is actually going to play out. We don't know how drastic USCIS adjudicators are going to be with this. Is it going to be like the 944 form adjudication, or are they going above and beyond that to deny all 485s unless there's just something incredibly extraordinary about the case? We don't know yet.
Yeah, and I think you nailed it, Emily. I mean, people like to think immigration lawyers fearmonger, and I would say in this case, it's being cautious and advising you to be cautious until we know. We have a memo that kind of changes decades of immigration, okay? Practice, principles, understandings, upends it in a memo, okay, that's released on Friday morning. So we don't really know how it's going to be implemented. And until we see trends, until we see guidance, until we see whatever, I agree. It's better to be cautious with travel, with abandoning your non-immigrant status, which again, I think is stupid. You should be able to. But it's better to be cautious until we know for sure.
I'm responding to Reguland. Can I extend the H-1B based on the I-140 approval? Yes, you can. This memo is not applicable to the extension of the H-1B based on the I-140 approval. You can still continue doing so. For the people who are about to file the adjustment of status right now, I will still advise them to file the adjustment of status, whether it's a family-based immigration, whether it's a employment-based immigration. As Emily has pointed out, I probably will try to collect the documentation that why you change the status, why is it you need the adjustment of status here instead of going to consular processing. But I will still file the adjustment of status right now. Emily, what do you think?
Yeah, I agree with that. I think I would include the positive discretionary factors in the filing, but otherwise go ahead and file it. Just continue to maintain your non-immigrant status while we wait and see how this is actually going to play out.
Any litigation part, Stephen, on this? What
I think it's being formulated. I've been talking with multiple lawyers this morning while I've been talking with folks while we've been on live. I mean, I think there's definitely things being formulated, I think the tough part, and I think there's ways around it, is, finding plaintiffs with standing, because nobody's harmed yet, right? We have a memo, but nobody's harmed yet. Now, I think there's good arguments that there's imminent harm because of what we talked about at the beginning, and I think there's ways around it. But I think finding the right way to challenge it is going to be important. But I know, been texting with folks, talking to folks, tweeting with attorneys, emailing while we've been on here. The wheels are turning. I think something will come. Might not be tomorrow, but I think it's in the works.
Anything else?
Nope. Let's see how this plays out. Unfortunately, we're in a wait and see mode, very similar to what we experienced with the $100,000 fee proclamation that happened on a Friday, and we saw how things adjusted over the weekend into the following week. So we'll have to do the same this time around.
Thank you very much for tuning.